Please be seated. We'll hear argument in 21-727, Maxim Crane Works against Zurich American Insurance.
May it please the court, Mr. Long will present argument for the appellant. Appellant has reserved 5 minutes for rebuttal.
Good morning. I have with me Elijah Stone, whose unenviable task it was to make sure I didn't mess up our briefs. I'm happy to represent Maxim in this important matter. We also appreciate the opportunity for in-person oral argument. The issue certified to this court presents a case by the Fifth Circuit presents a case of first impression. In our view, it's one that's likely to recur. Lots of construction projects in Texas, one can just look out one's window and see all the cranes. And there's an increasing use in Texas of both CSIPs, contractor-controlled insurance programs, and OSIPs, which are involved here. In this case, it's a CSIP. The central question is whether the term employee, as it's used in the employee exception to the Texas Anti-Indemnity Act, should be construed narrowly to only apply to an employee, or whether it should be construed slightly more broadly to apply to a co-employee. There's no Texas case that has addressed this issue as to what employee means exactly in the context of the Texas Anti-Indemnity Act, or what the term co-employee means in that context. What is clear from Texas case law on this issue is that there's no surgical precision as to what exactly these terms mean in the context of contracting relationships in construction projects. Various cases have used various terms. They describe the relationship sometimes as employer-employee, co-employer, co-employee, fellow servant. So there's a lot of fog in the Texas case law as to what an employee actually means in the context of a multi-tiered construction contracting situation.
Don't we have to look a little more broadly under 151-103? It doesn't just say employee, it says employee of the indemnitor, its agent or its subcontractor of any tier. And here effectively, Burkle is effectively the indemnitor by virtue of the equating additional insured status to an indemnity in another section of the statute. So don't we have to just look at not whether this was an employee, but whether they were an employee of Burkle?
Yes, the exception, the employee exception, is actually broader than just employees. It as you said, it applies to employees, and then employees of agents, employees in the indemnitor, then right. Employees of agents, and then employees of subcontractors. But
we don't have an issue as to agents or subcontractors here.
We do not in this case.
Okay. So the whole question was the injured party an employee of Burkle?
I wouldn't phrase it exactly that way. I would frame it as whether the word employee should be construed under the TIA employee exception to cover co-employees, and I'll explain why I think it should.
But wouldn't it have to be a co-employer in order to be covered under that language?
If one way of finding coverage for an employee is to deem a party its co-employer, and as I will explain in the TIC Energy case, those types of terms have been thrown around quite a bit by Texas courts describing these relationships. And so whether it's a co-employee or a co-employer, it is effectively the same legal relationship under the Texas Workers' Compensation Act.
But if we disagree with you about that and think there's a difference between being a co-employee and a co-employer, then don't you have to prove under 151-103 that Maxim was the co-employer in order for that section to apply?
It wouldn't be whether Maxim is, it would be whether Burkle is.
I'm sorry, right,
yes.
Whether Burkle is.
I don't believe we have to prove that they're the co-employer. I believe that the legal status granted on them as a co-employee is effectively the same legally in Texas as a co-employer for reasons I can explain, which is that under the Workers' Compensation Act, the effect of being a employee or a co-employer is full workers' compensation immunity when there's a CSIP, a contractor-controlled insurance program. So every party up and down the contracting tier and all of their employees are deemed to be essentially fellow servants. The effect of that is that each party up and down the contracting tier gets full indemnity from claims by any employee within that tier. And that's how the Texas Workers' Compensation Act works when a CSIP applies.
Please go ahead. It seems that the labor code tells us that these co-employee, co-employer, this way of looking at employee is only for purposes of the workers' compensation laws, and it says that pretty clearly. So, how do we get past that and apply it outside of the worker compensation laws, as you're asking?
Sure. It is not our position that definitions in the Texas Workers' Compensation Act are intended to be imported into the Texas Anti-Indemnity Act. But rather that when one looks at the terms in the Texas Anti-Indemnity Act, that those definitions and approaches provide context, particularly here when there's a contractor-controlled insurance program involved.
But doesn't that statute also seem to explicitly state that it has no effect on workers' comp laws?
Yes, it doesn't affect them. In other words, there's nothing specific about the Texas Anti-Indemnity Act that overrules workers' compensation laws. But I think the reading that we propose for the employee exception actually works completely in harmony with the Texas Anti-Indemnity Act. And that is for the following reason. The Texas Workers' Compensation Act, as I said a minute ago, involves a situation when there's a CSIP where all parties up and down contracting tiers and all of their employees get tort immunity and the worker gets workers' compensation coverage. And so, and there's lots of commentary on this, both in case law and among commentators, scholarly articles and so on. And the approach is exactly correct, which is that when there's a CSIP, what happens is every single employee is effectively deemed to be the employee of everyone at that job site or the co-employee. The effect of that is nobody can, that the injured employee cannot make a claim, cannot make a tort claim against any of those project participants who are covered by the CSIP. The oddity in this case is that Maxim Crane, our client here, was not covered by the CSIP because it was excluded from it. And so had Maxim been in the CSIP, we wouldn't be here at all. Not only that, had the crane fallen a different direction and injured an employee of Berkel or an employee anywhere down the contracting chain or an agent, an employee of an agent or employee of a subcontractor, we wouldn't be here either because clearly under the Texas Anti-Indemnity Act, indemnification and correspondingly additional insured coverage would have been allowed in that scenario.
But isn't that exactly the way the legislature wrote the statute, that if it's you or somebody downstream under 103, then it's excluded, but they didn't say anything about upstream?
They did not say anything about upstream in the employee exception. It appears to be as written downstream.
So why shouldn't we assume that that was intentional?
Because it's inconsistent with the provisions of the Workers' Compensation Act. It would be odd for a situation to exist, as exists here, where Berkel, which toppled the crane and injured Skanska, the general contractor's employee, gets complete workers' compensation protection, and yet through essentially a trap door or a loophole, manages to escape its contractually agreed duty to provide insurance coverage to Maxim merely because the person injured was not their employee, but rather their co-employee.
Is it because of a trap door, or because Maxim did not participate in the CSIP? And would that have been available to Maxim?
Yes, Maxim did not participate in the CSIP, and it's laid out in our reply brief why they were excluded from it. The CSIP excluded from participating parties or enrolled parties, among other things, companies that supplied material and equipment to job sites. And it's set out right in the CSIP itself, which, by the way, was also issued by Zurich. So Zurich knows very well what its CSIP allows and doesn't. But in this case, Maxim was not eligible for the CSIP. And there's a reason for that. I mean, all Maxim did here was deliver a crane to the site. And that's exactly why they got indemnification from Berkel and also insurance from Zurich, because all they did is drop off the crane at the site, and after that it was completely within Berkel's control. And so they never were in the CSIP and never could have been. One of the issues
they couldn't have been?
Couldn't have been, yes.
Why is that?
Because they're excluded from the definition of enrolled, permitted enrolled parties from the CSIP that Zurich
Could
issued.
that have been negotiated? Or they're just categorically ineligible, and there's nothing that anybody can do to change that, even if they want to?
As both an insurance and construction lawyer, I've never seen a party that's excluded from a CSIP somehow bargain to get itself into one. This is a program set up by Zurich, and there's a reason. I mean, typically CSIPs apply to people who actually work at the site, and they don't apply to people like equipment suppliers. If you supply a boiler, or if you supply, a piece of machinery, you're typically not in the CSIP, because CSIPs principally cover workers' compensation exposures. And of course, Maxim, which simply delivered a crane to the site, wouldn't have had those exposures on its own right.
This issue wouldn't have arisen, right, if the jury hadn't found Maxim partly liable?
That's correct. I mean, Maxim, for reasons that are very difficult to fathom, other than them being on the jury slip, the verdict form, Maxim was found 10% negligent, even though all they did is deliver a crane to the site. But
So at least according to the jury verdict that's in place, Maxim didn't just deliver the crane to the site, they had partial responsibility for this incident.
I would say, according to the jury slip, they were apportioned 10% liability. There's no specific finding by the jury as to why. Not surprisingly, it was simply
Right, but if it's, we have to accept that finding, right, if it hasn't been overturned on appeal, which it hasn't.
Yes,
I
that's correct.
understand.
One of the discussions the parties had in their briefs is about what this court should do in terms of construing the TIA itself. That is statutory construction. And I think we have I would say, a spirited debate about what this court either historically has done or in our view should do in construing statutes. Zurich argues for what I would call sort of strict constructionist or literalist approach. And that has historically not been the rule in Texas. Why not? Texas, among other things, there's the Constructions of Law Act, which instructs a court to sort of look at the purpose and intent of a statute. Now, admittedly, if the language is crystal clear, then the court simply construes the language. But even then, Texas commentators have suggested that the court should try to do it in a way that looks at the purpose and intent of the statute. So why is that important here? Because unquestionably, under the employee exception to the Anti-Indemnity Act, Burkle could provide indemnification to Maxim for injuries to Burkle's own employees or employees all the way down the contracting chain. So the question is, when that is completely allowable under the Texas Anti-Indemnity Act, why should it be any different merely because the crane fell in one direction versus the other and injured an employee one step up in the contracting chain? There's simply no evidence from the legislative history in the TIA.
So there's a difference, right, between saying we're going to look at the purposes of the statute to inform our inquiry into what the words mean, and we can have a separate conversation about whether that's appropriate. But your position seems to be the statute says what it says, but it just wouldn't make sense given its purposes to apply it to this situation, and so we shouldn't.
I think it's
Is that your position?
That's one of two, but you've accurately summarized one of them. The other is simply that the word employee in TIA is not defined, and so it's not crystal clear on its face whether it could apply to both an employee and a co-employee or some other relationship as existed here, like a fellow servant. And in that sense, one of the cases that I think discusses this issue very ably and thoroughly is the TIC Energy case, which is this court's decision from 2016, and it's footnote 45 in the TIC Energy case. And that case makes the point that the description of relationships in these very complex contracting tiers, when a CSIP or OSIP is involved as an OSIP in that case, is not a completely precise exercise. And this court says in 2016, the statutory employer-employee relationship extends throughout all tiers of subcontractors, and all covered employees are fellow servants who are equally entitled to workers' compensation benefits and equally immune from suit. And then the court cites the Garza case. Then the court goes on to say, subcontractor and its employees are deemed fellow employees of the general contractor's employees and therefore entitled to exclusive remedies defense.
And that's a workers' compensation case, right?
It is.
So the passage you just read suggests that this whole concept of co-employee, co-employer comes from the statutory definition of employee and employer in the Workers' Compensation Act, which the Act tells us applies only within the workers' compensation context. I think that's the That's what you really need to grapple with, I think.
Well, and I have. We are not suggesting that you take a definition out of the Texas Workers' Compensation Act and import it into TIA. Had the legislature decided to do that in the Texas Anti-Indemnity Act, it could have done so by cross-reference. And Texas statutes frequently do that, take that approach.
If we don't import it, aren't we left with the traditional definition of employee, which would not include someone else that wasn't hiring, firing, responsible for the details of the work, that kind of thing?
I think the point of the TIC Energy case is that even trying to say what a traditional definition of employee in Texas case law in these very multi-tier contracting situations is not that clear. That is, because, for example, if Mr. Lee, had he been injured by another subcontractor, including one that was farther down the tier, the result would have been the same, right? He would have gotten workers' compensation protection under the CSIP, and the whoever injured him, who was in the CSIP, would have gotten workers' compensation immunity. And so when one turns to figure out how should employee be construed in the Texas Anti-Indemnity Act, one has to look at the case law that says these concepts are not precise. Who's an employee or an employer or a co-employee or a co-employer in any particular context, or a fellow servant, is not a surgically precise definition in Texas, and it never has been. Essentially, the court is called upon in this certified question to construe what should employee mean in the TIA. It's not defined, and so where does one look? One can look at case law, one can look at definitions, one can look at a variety of sources. When one looks at case law, and there are lots of cases, not surprisingly in Texas, under the Texas Workers' Compensation Act, trying to figure out who has immunity and who does not in these multi-tiered contracting situations, which is very typical in large construction projects. When one looks at these definitions, one sees that they're not at all precise. So then the question is, if you're trying to do justice to what the legislature seemed to be doing, we think that our interpretation is more plausible than Zurich's, because it is clear as a bell the Texas legislature allowed and had no qualms allowing indemnification for injuries to one's employee and anyone down the contracting tier. So why should it make a difference if the person who got injured here was one click up the contracting tier? It just makes no sense to have such a fine distinction.
Your time has expired. Are there any other questions? Thank you, Mr. Long.
Thank you.
We'll hear from the appellee.
May it please the court, Mr. Bowman will present argument for the appellee.
May it please the court, good morning. It's a pleasure to be here. I wanted to start off just by pointing out that I think what the court has already gleaned from Maxim's argument, what they're asking the court to do today is to apply a very results-oriented approach that bypasses attempting to construe the actual statutory text and going straight to legislative history and public policy, something that this court has consistently admonished litigants against doing when the statute itself is clear on its face. There's a couple of admissions that I think inform the scope of what we're looking at today. Maxim's reply briefing on page 4 admitted that when we're looking at that language, employee of the indemnitor, yes, under the common understood meaning, Lee is not Burkle's employee. And under the workers' comp definition, Lee is not Burkle's employee. So they've admitted several times that the debate is not really over who he was actually employed by. They admit that he was employed by Skanska, a higher tiered contractor. That alone should get us to a point, looking at the plain language, to be able to determine that the employee exception here does not apply. As Justice Busby mentioned, if we look at the language itself, employee of the indemnitor, its agent or subcontractor of any tier, that situation does not arise here. The other admission we heard Maxim make during their argument was that, of course, the legislature knows how to use cross-references when it wants the court to bring in an interpretation from another statute, and that it didn't do so here. And in fact, as the court has pointed out several times, the labor code where the Workers' Comp Act is located actually states that the treatment of the line of employer, subcontractor, and subcontractor's employees are treated that way only for purposes of the workers' compensation laws of this state. So when we're looking at legislative intent, we have a clear legislative directive that we are not to construe the Workers' Comp Act definitions or the case law construing those definitions for any other purpose than workers' comp.
Do you agree with the appellant that it doesn't seem to make a lot of sense for the result to be different, whether Lee was employed by the general contractor or the sub?
Well, when we're looking at the legislature's enacted language, it does make sense that we have to treat it differently because the legislature could have articulated any employee on the project.
Right, but other than the legislature said so, which I take your point,
Right.
Is there any other explanation for why it should be different?
Well, I think, I appreciate that opposing counsel's made an argument that employee, whether it's under workers' comp as a co-employee or whatever, the effect should be considered. What the problem with that is we don't have any indication from the legislature that that's what was intended. And we don't even have case law that specifies that that's what's intended. The legislative
There's some indication
intent.
in the briefs, right, that there was a concern being addressed at the legislature about cramming this down on
Right.
parties below you in the chain.
Right. That was expressed in one of the sponsors' notes who expressed, I believe it was Senator Duncan, who also expressed that the goal of the statute was to ensure that parties were solely responsible for their own negligence. I think what would happen if the court were to adopt Maxim's interpretation today is that we'd have even more of those crammed down scenarios. If the employee exception is going to be construed so broadly to where it's any employee on the project, then we're going to have even more of these indemnity agreements being enforced. So the very legislative purpose that they cite would be directly contradicted by the court finding for Maxim today.
But is there as much leverage to cram it up as there is to cram it down?
I don't see any leverage to cram it up, and I take issue with Maxim's statement that these workers' comp cases use co-employer, co-employee terms interchangeably. That's why we submitted Exhibits 1 through 3. Exhibit 1 outlines the Austin Bridge case, where it was an OSIP, and Baylor University was the owner, and it was straight vertical privity between all the parties there, so that every party below Baylor was considered a co-employee of Baylor. And then with regards to the injured employee at the bottom, everyone above that employee was a co-employer. So those terms are used specifically even in the workers' comp context. And again, we're sort of already far afield of a plain language interpretation if we're talking about how to apply the workers' comp definitions in the Anti-Indemnity Act. But even if we were to do that, none of it makes Lee Burkle's employee, because Lee is the employee of a higher tiered contractor. So there's no construction, even of the definitions under the Workers' Comp Act, that works under these facts. And I think that's the reason Maxim's argument has somewhat shifted over time. When it was in front of the Fifth Circuit, it focused a lot more on how the Workers' Comp Act was construed, and we debated the issues between these cases. The way that Maxim has proposed the certified question to this court doesn't even mention the Workers' Comp Act in its issues presented anymore, even though that was the question specifically presented by the Fifth Circuit. And I think the reason for doing that is because they recognize that if you apply that definition under the workers' comp case law, it still doesn't work, because Burkle is not a co-employer of Lee. Burkle and Lee are co-employees of Maxim, and so of Skanska, the general contractor. So the associations in this case don't support using a workers' comp definition that would actually trigger the employee exception. It still doesn't work. And I think that's why the question I would ask of Maxim is, how do they actually want to define employee in this case? Because they seem to be avoiding saying they want to use the workers' comp definition, but then saying they want that to inform the court's interpretation of how to define employee. And so I'm still unsure, as we sit here today, with the argument that has shifted over time, how exactly they want the court to construe employee, other than to say ultimately they want the result to be that the employee exception is triggered and Maxim benefits in this case. But I don't see how that creates any workable rule that the court can apply in cases going forward.
Could Maxim have enrolled in the CSIP? That was something that your from the other side resisted strongly this morning.
I'm glad you mentioned that. So statutorily, yes, under section 151.0015, equipment lessors are defined as parties that can participate in these construction contracts. They cited into the record at 661 provisions stating that Skanska, as the general contractor administering the program, would not include equipment suppliers. However, in that same sheet on 661, or that starts on 661, they also say that including parties in the CSIP is solely at the discretion of Skanska. So Skanska could have still decided to include parties within the CSIP even if they didn't fit that definition. And we don't have any evidence in the record that that Maxim ever approached Skanska and was rejected of an opportunity to be part of the CSIP. And the other circumstance I think that would address any concerns about how this goes in the future is Maxim also could have contracted with Skanska, the general contractor, and then any employee or subcontractor under Skanska would have been considered an employee enrolled in the CSIP, an employee of the indemnitor, and then Maxim could have triggered that employee exception. So there are avenues to address this on construction projects. I think Maxim's problem with how things have turned out here is just a result of how it contracted. And unfortunately, it can't revisit that.
On the first one, would it be reasonable to read the definition of those who can participate to exclude them and to see the discretion that Skanska would have to mean that even those who are potentially included, they can be rejected, as opposed to we can just ignore the definition that we've put into place about who can participate?
I just want to be sure I understand your question. Is it that if they were accepted into the CSIP, they could, at their discretion?
Well, like those who can, can the construction suppliers, the equipment suppliers participate? No. Then I think what I understood you to say is, but they have full discretion. And so my question is it one step thing, which really means the discretion to allow whomever to participate? That's the only real question, or is it a two-step? First, we figure out who is by definition allowed to participate, and then there's discretion about whether to nonetheless exclude them, or am I reading that wrong?
I read it as the latter, what you just stated, that there's a definition.
How would that help Maxim then?
I'm sorry?
How would that help Maxim?
Applying the definition first and then getting to discretion?
Yeah, because if they're excluded initially, and then the discretion is to simply further exclude people who otherwise would be permissible. Am I getting this backwards?
No, I think it's even if you don't fit within, if you fit within the definition of a party that could be excluded, which has been raised for the first time by Maxim in its reply, that you could still approach the general contractor and be admitted into the CSIP.
But that's how you read the discretion.
Yes, and that's outlined in the record, page 661, which goes through Skanska having that discretion as the administrator of the program. I know the court's very well aware of its plain language precedent and why it would govern interpretation of this case, but I did want to go through just a little bit of the policy behind that, because I think it really highlights some of the issues that would be problematic here.
Before you get to that, is it slightly odd for us to answer this question here, given that this case started in state court and then was removed to federal court? Do you really want our answer versus the Fifth Circuit's answer?
I was fine with a Fifth Circuit answer, but they saw it fit to certify it to this court. I think the issue is ultimately it's a state statute that hasn't been interpreted by a Texas court yet, and the Fifth Circuit was hesitant to be the first court to weigh in on that. So whether we're in the Fifth Circuit or here, I think either court could address it. We thought the Fifth Circuit was well equipped to do so because the plain language was so clear and because this court's directive has always been to apply the plain language. But I think ultimately they saw fit for this court to be the first court to interpret that statute, since no other court had done so. So I don't, is that answering your question?
It seems strange for us to answer in some ways. I mean, the Fifth Circuit has certified it and we accept those questions, but given that you didn't want to be in state court, it seems strange for us to answer this question for you.
It's unique. I guess it's somewhat funny, but I think the removal was based on diversity, and it simply has ended up this way. The district court at the federal level, Judge Rosenthal, had no problem applying the exact approach we're asking this court to do, which is simply reading the plain language of the statute. And so whether it happens in the federal level or here, I think the result's ultimately going to be the same. And that is because this court has consistently been clear that the truest manifestation of what lawmakers intended is what they enacted. Just a few years ago in the Texas Health Presbyterian case, this court reminded us that we do not resort to extrinsic aids, such as legislative history, to interpret a statute that's clear and unambiguous. It even addressed the argument in that case that the Code Construction Act gave this court the freedom to do so, and this court rejected that argument, stating that not all that is lawful is beneficial, and that constitutionally it is the court's responsibility to construe the statutes, not the legislature's. The court does not determine what the legislature or any individual legislatures may have meant to enact, but what they enacted. And the reasons for that were articulated in that Texas Health opinion were that it's a three-pronged benefit. We encourage the legislature to enact unambiguous statutes. We discourage courts from usurping the legislature's role of deciding what the law should be. And we enable citizens to rely on the laws as published without having to worry that they may carry some hidden meaning. So that's exactly what we're asking the court to consider here, is that when we're looking at the language of employee of the indemnitor, which Maxim has admitted under a plain language approach really has to go our way, that's the interpretation we'd ask the court to apply. And ultimately, if there are policy considerations with the equities of that, the court even stated in Texas Health that they would leave it to the legislature to correct its own errors or omissions. So even under Maxim's recognition that the legislature could have used a cross-reference if it wanted to, there's none used here, and there's no reason to believe the legislature wanted these statutory schemes to be construed together. And in fact, we have directives from both statutes that were not to do so. The Anti-Indemnity Act specifically says this subchapter is not to affect the benefits and protections under workers' comp, and we then have a directive under the workers' comp statute that treatment is only for the purposes of the workers' compensation laws of this state.
Is there anything inequitable about Zurich accepting Maxim as an additional insured and providing coverage as an additional insured and presumably charging a premium for that, knowing all the while that no coverage would be provided because of the Anti-Indemnity Act?
And I wouldn't say they knew
Are there
all.
other circumstances where coverage might be extended to an additional insured in this context?
I don't think it can, Your Honor, under the Indemnity Act. And one thing I'll mention is that I know...
Well, it could have if Maxim had not been found negligent, right?
That's one issue, so thank you for helping me out there. Maxim is only paying for its 10% share of its responsibility. So Maxim's not being held responsible for anyone else's.
But if Maxim had not been... Right, okay.
And I think the court has outlined it well during petitioner's argument in stating that it really has to be a lower tiered employee or subcontractor or agent. If you're going to force a party to be responsible for any employee on the project, you're really letting the exception swallow the rule. And I think that would directly contradict the legislative intent that Maxim has cited and brought to the court's attention.
So your position is that Zurich wouldn't invoke the Anti-Indemnity Act if the employee involved was a subcontractor of Burkle, and so you would look to the Texas Workers' Compensation Act to inform the definition?
I still don't think you'd have to look to the Workers' Compensation Act. In fact, and just to be clear,
because of the subcontractor in the statute itself?
you would still just be under the anti-indemnity statute. And that's how we believe this should be resolved fully, is I think the question ends at, under the Anti-Indemnity Act, plain language interpretation, it has to be an employee or a lower tiered contractor. But even if we were to get into those workers' comp analysis, which we're directed not to, this is still a higher tiered employee. There's no reason to try to wedge Lee into being an employee of Burkle in this case.
But even if they'd been sued by Could they get defense costs, for example, if the jury had found no liability on Maxim, even though it was an action by an employer of a higher tiered contractor because there was no liability found?
And I got lost in the hypothetical.
Okay, so same facts as here.
Okay,
Jury finds 0% on Maxim. Maxim is not liable.
Right.
Could Maxim then claim under the policy, under Burkle's policy?
I wish I had more time to think about it, but I think my answer is there could be a claim there because ultimately you're not
For the
seeking
fee,
indemnity
fees,
for your
or maybe you
own-
provided a lawyer, but
Right.
they wouldn't have to pay back the fee.
I think, right, because you're not seeking indemnity there for your own
your own
negligence under that
negligence.
scenario. Right. And I think ultimately what the statutory framework creates is basically an either-or scenario. The legislature has said we want parties to be solely responsible for their own negligence. The exception to that is you can agree to be responsible for injuries to your own employees or your own subs regardless of fault. So that gives the parties a freedom to contract how they want to govern this kind of risk. But if the exception is interpreted so broadly to where it's not even your employees that you're agreeing to be responsible for anymore, you're really swallowing the prohibition against indemnity and directly contradicting the purpose of the legislative act. So again, I think petitioners argued somewhat on this cram down argument, which I think would only be exacerbated by broadening the definition. We don't really have any evidence in the record to support any argument regarding unequal bargaining power or anything of that sort. It was raised in the briefing, but if anything, I think opposing counsel would admit that Maxim is the larger company here, and there really isn't anything in the record to support any facts regarding bargaining power. We do know that where the lease appears on page 691 of the record, this was a Maxim lease. And it even stated that it was enforceable to the fullest extent permitted by Chapter 151. So this doesn't come as any kind of surprise to Maxim that Chapter 151's provisions are enforceable here. Maxim's entire argument in this case is really based on treating Lee as a co-employee of Burkle because they were deemed co-employees under the workers' comp statutes. But not only does that violate the workers' comp prohibition on applying its treatment outside of workers' comp, but factually it makes no sense under these circumstances. Lee was an employee of a higher tiered contractor. And again, if we were to construe the exception so broadly, it really would swallow the rule in this circumstance. One issue raised, opposing counsel's brief cited to Senator Duncan's statement of purpose that the prior law before the Anti-Indemnity Act basically made the insurer, the subcontractor, potentially an insurer of the entire project whenever these provisions were crammed down upon them. That's exactly what we would be going back to if we were to construe the exception so broadly that a sub could be responsible for injury to any employees on the project. So the danger there is really that we would directly thwart the purpose of the legislature, and it's not warranted by anything that opposing counsel has pointed to, either in the legislative intent or case law addressing the statute. So if there are no further questions, we ask the court answer the certified question in the negative. Thank you.
Any other questions? Thank you, Mr. Bowman. Lon, you have 5 minutes.
Thank you. I want to start with the questions that the court has asked and deal with those sequentially and then see what else the court maybe want to talk about. We did sue in state court. We thought that this was an issue of first impression for a state court to decide, and that's why we sued in state court. Here we are after rattling around in the district court and the Fifth Circuit, but we think this question should be answered by this court. Participation in the CSIP. They accused us of raising this issue for the first time, but that's not actually true. Zurich raised it in its brief. We simply responded to it. The issue is very simple. If you read the terms of the CSIP, we weren't eligible to enroll. Yes, in theory, we could have gone to Skanska and got an exception, but Skanska wasn't Maxim's customer. Burkle was Maxim's customer. Why is that? Burkle's the drilling contractor at the site. They were the one operating the crane and drilling. So there's really no scenario under which, as a bare equipment supplier that leased a crane to Burkle, we would have gone in and started negotiating different insurance terms under a CSIP with Skanska. That just would never have happened in a construction project, and certainly not one here where Burkle was our customer.
But you read the text on page 661 the same way that your friend on the other side does, in terms of the discretion that Skanska.
Yes, Skanska could have allowed us in, but it would have required us to think to ask, have Skanska do it. But none of that matters, because the bottom line is that never happened because Burkle was our customer and not Skanska. We had no contractual relationship with Skanska, no commercial leverage, nothing. Statutory interpretation. One of the things about statutory interpretation in Texas is if one goes all the way back to the 1930s and 1940s, there's something for everyone here. What I would suggest is this court has historically not applied what I would call a pure literalist approach, a pure construction approach. It has looked very hard at what the words mean, but also what the words mean in the context of the statute and case law regime as a whole. And Ron Beal, in his excellent Baylor Law Review article that's cited in our briefs, goes through this in quite a lot of detail at what the different approaches are. What I would suggest to the court here is that context can be important. And when the context of the statute is that the legislature had no qualms whatsoever allowing indemnification for injuries to an employee, there's simply no practical or logical reason why that would be any different for an injury to a co-employee. Perhaps the senators or the House representatives who drafted this bill could have said employee and co-employee. They didn't, but that's really a case law concept. And in that light, one thing that's very important to note is Zurich says we're trying to import definitions from the Texas Workers' Compensation Act. We're not. We're just suggesting that regime provides backdrop for how to interpret the Texas Anti-Indemnity Act here. But you can scour the Texas Workers' Compensation Act, and one thing you will find is that the word co-employee is not defined anywhere there either. And so what we're trying to figure out is, in the context of TIA, should employee be construed to include the concept of a co-employee under these facts. Zurich says that if you apply a plain language approach, we lose. We don't agree. The question is, what does employee mean, and should employee be construed to include co-employee? And that is our position. I'm the son of two college English professors, so I like words. And one could argue that co-employee is simply a different form of employee. I mean, it's a hyphenated form of employee. So,
but if we read the statute that way, it would say a co-employee of the indemnitor, which is Burkle. So who was the co-employee of Burkle?
I think the way this is written, I don't know because it wasn't decided in the case, but I think the ruling would have been that any employee of any contractor anywhere under Skanska or subcontractor would have been a co-employee of Burkle. That's when there's a CSIP, that's exactly what the Workers' Compensation Act says, is that each employee of anyone anywhere down the chain from the sponsor of the CSIP.
But here it would have to be sort of sideways in the chain to pick up Maxim.
This is a quirky situation because the crane fell one way instead of another. If it had fallen and injured a Burkle employee, we wouldn't be here. What happened, though, is Burkle toppled the crane, and instead of injuring its own employee, which was probably just as likely, it injured a Skanska employee. But the bottom line is the legal regime is exactly the same. Everybody got workers' comp protection and tort immunity, and the employee sued the only party it could, which was Maxim, and we say that makes no practical difference or shouldn't under the employee exception.
Any other questions? Thank you, Mr. Long. Case
Thank
is
you.
submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.